I present to you the first video on the land law series by the law professor. Introduction to land law. In this video, you will learn the historical and legal background of various land legislations, and you will also be able to appreciate the need for those legislations and the constitutional provisions concerning land legislations in India. Well, it is essential to lay a strong foundation before we start to know the subject, isn't it? Hence the video.
Land is precious. Land is desired and the most disputed too. Historically, India was ruled by different kings who had their own different system for land and land revenue collection. The land use was mainly divided into jagirs, which were allotted to jagirdars, who further split the land and allocated it to the subordinate zamindars. It was the zamindars who made peasants cultivate the land and in return collected part of their revenue in the form of tax. After the British took the reign, things only worsened. India was systematically robbed of her riches for 2 centuries. Under the British rule, they allowed the existence of non-cultivating, parasitic intermediaries who served as an economic instrument to extract high revenues as well as sustaining the political hold on the country. Permanently settled estates were created during the time of Lord Cornwallis in around 1793. The holders were proprietors known as zamindars. The land tenure system known as zamindari system. The revenue collection system prevalent during the British era was only a source of exploitation. The land was concentrated in the hands of a few, who in fact were rarely cultivating the land personally, and those who actually did were looted and exploited by the revenue officers and the state alike. The rental amount collected would be divided into 11 parts, whereas 1/11 of the share went to the zamindars and the remaining of 10 out of 11 share belonged to the East India Company. Subsequently, the Roy-Barry system by Thomas Munro in 1820 and Mahalbari system by Lord William Bentinck in 1833 were introduced. The British, through these and other related systems, aimed to collect maximum revenue possible, and hence these were designed accordingly. The interest of farmers was never a priority.
There was a need for good policies, legislations, and organized system of revenue collection post-independence, as India had to tackle many interconnected issues. While agriculture was a major source of revenue, land reforms were introduced to fight the evils clogging the agricultural system. The Zamindari Abolition Act and Land Ceilings Acts were passed. Different states fixed an upper limit for private land holdings of a family. There was an abolition of the intermediaries, reforms for tenancy, and of land usage, land ceilings, and its redistribution. In Karnataka, Mysore Personal and Miscellaneous Inam Abolition Act 1954 abolished the inams. Karnataka Land Reforms Act 1961 was enacted based on the report of committee called the Mysore Tenancy and Agricultural Land Law Committee under the chairmanship of B.D. Jati in May 1957. The then Chief Minister Sri Devraj Uris was instrumental in this bold move. After the 44th Amendment, right to property remained a constitutional right. Originally, the Constitution under Article 19 guaranteed to all citizens the right to acquire, hold and dispose of property. Whereas Article 31 provided that no person shall be deprived of his property save by authority of law. Compensation would be paid to a person whose property has been taken for public purposes. The 44th Amendment removed the right to property from fundamental rights, and a new provision under 300A was introduced where no person shall be deprived of his property save by authority of law. Land is a state subject under List 2 of Schedule 7 under Indian Constitution. When in Entry 18, state can make laws relating to rights on and over land. Entry 45, revenue collection. Entry 49, tax on land and building. Land is a state subject, but acquisition of property is on concurrent list, which means both state assemblies and parliament can make laws that govern it. But in case of conflict, the central law will prevail. However, the old draconian British period Land Acquisition Act 1894 was retained with modifications through amendments until the recent enactment of Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. RERA came into force only in 2016. After this brief introduction to the history of land laws in India, we need to understand another principle which forms the basis of land acquisitions: the principle of eminent domain. It is based on this principle of eminent domain that the governments acquire land from private parties for developmental purposes. The principle recognizes the right of the government to take away the property belonging to private individuals for public purposes on paying adequate compensation. The approach of these legislations are way too different. So to sum up today's class, we've studied that land revenue system in early India depended on monarchs and local custom. British system of land revenue collection led to exploitation and misery. Post-independence, the nation had to tackle various challenges. The land reforms and different land legislations were enacted. Land Acquisition Act 1894 was retained. Right to property remained just a constitutional right after Constitution 44th Amendment. Land falls under the state list, that is Schedule 7 List 2, whereas acquisition of property falls under the concurrent list. The eminent domain principle is recognized by countries and it approves acquisition of private property by government for public purpose on compensating for it. So that's all for today. Do check our other videos on how to write the law exams and moot courts. Thank you. Take care.